The concept of national security is frequently invoked in legal and political discourse, often serving as a cornerstone for justifying a wide range of state actions, from restricting civil liberties and conducting surveillance to launching military operations and suspending human rights obligations. Despite its centrality, a closer examination of international legal instruments reveals that national security remains an elusive term, not clearly defined in international law. The absence of a universal definition is not accidental. Rather, it reflects a deliberate choice by states to maintain a degree of flexibility. National security concerns are often context-specific and evolve with time, technology, and geopolitical dynamics. What may constitute a threat to one country might be seen as benign by another. As such, international treaties, including foundational documents like the UN Charter, the International Covenant on Civil and Political Rights, and the Geneva Conventions, refer to national security, but none provide a definitive description. This lack of clarity is particularly evident in the International Covenant on Civil and Political Rights. Article 4 of the Covenant permits states to derogate from certain rights in times of public emergency, an exception often associated with national security threats. Similarly, Article 19, Paragraph 3 allows for limitations on freedom of expression to protect national security. However, the Covenant offers no concrete guidance on what constitutes such threats, leaving it to states to interpret. To address this gap, a group of legal experts developed the Siracusa Principles in 1984. While these principles are not legally binding, they are widely respected and frequently cited. They suggest that national security should be narrowly understood to mean the protection of the existence of the nation or its territorial integrity against the use or threat of force. The Siracusa Principles emphasize that any restriction based on national security must be lawful, necessary, and proportionate, not vague or arbitrary. Despite their influence, however, these principles remain soft law, guiding rather than governing. The situation is similar under the European Convention on Human Rights, or ECHR. Article 15 allows derogations in times of war or public emergency that threaten the life of the nation. Other provisions, such as Articles 8, 10, and 11, permit restrictions on rights for the sake of national security. Yet again, there is no definitive statement of what national security entails. The European Court of Human Rights, or ECHR, has provided interpretive clarity through case law, emphasizing the importance of strict necessity and proportionality. For instance, in the case of A and others versus the United Kingdom, the court scrutinized the UK's indefinite detention of foreign nationals under anti-terrorism legislation. While it acknowledged the national security concerns following the 9/11 attacks, it ultimately ruled the measures disproportionate and discriminatory. Complicating matters further is the wide variance in national definitions of security. The United States tends to focus on military threats, terrorism, and espionage. China adopts a far broader view, encompassing everything from ideological and cyber threats to economic and regime security. Countries like Pakistan, dealing with internal conflict and insurgency, often equate national security with political stability, justifying expanded powers for law enforcement and military institutions. This lack of a shared definition creates several challenges. First and foremost is the potential for abuse. In the absence of clear legal boundaries, governments may invoke national security to silence dissent, justify censorship, or detain individuals arbitrarily. Numerous reports by the UN Human Rights Committee and special rapporteurs have highlighted how loosely defined security justifications often come at the expense of civil liberties. Furthermore, international cooperation is hindered by the term's ambiguity. Efforts to combat transnational threats, such as terrorism, cyber attacks, or organized crime, require shared understandings and standards. Without a common framework, states may find it difficult to agree on intelligence sharing protocols, extradition treaties, or coordinated military responses. Finally, the indeterminacy of national security has legal implications. International courts and human rights bodies stress the need for transparency, legal safeguards, and judicial oversight whenever national security is invoked. there is a growing recognition that while states have a legitimate interest in protecting their populations, this must not come at the cost of eroding the rule of law. In conclusion, national security remains undefined in any comprehensive, legally binding manner under international law. While treaties refer to it and jurisprudence has offered some interpretative contours, there is no single authoritative definition. Instead, the concept is shaped by the evolving needs and narratives of individual states. Instruments like the Siracusa Principles provide useful guidance, but the international legal community continues to grapple with the tension between national sovereignty and universal human rights in the security domain. The challenge lies in balancing flexibility for states with accountability, ensuring that the invocation of national security does not become a carte blanche for repression.